Hi guys. Hi guys, Alina Shaltsova here, immigration attorney from New York. Today we're going to have our live about family-based immigration and mistakes that happen during the family-based immigration. So this video will be useful for those of you who are going or planning on sponsoring somebody, your relative through immigration, your spouse. If you received already status and you have a green card or you have a citizenship, or if you are planning on winning asylum and sponsoring your child or your spouse after you win your asylum, so you will know what not to do. Let's start, right? Let's start. So it's an interesting topic. The reason why I wanted to have this topic again is to help you guys a little bit to understand what's happening, why it's important to know that. So family-based immigration can start for most people when they are green card holders. When you're a green card holder, you can submit your family-based petition for your spouse, a child who is under 21, and a child who is not married and above 21. But as long as you're a green card holder, you will not be able to sponsor your parents. So there is a benefit in receiving U.S. citizenship. Once you become a U.S. citizen, you can sponsor married sons and daughters, children who are over 21 and married, and you can also sponsor your parents. It's very important. For example, if you are a green card holder and you filed a petition for your son or daughter who are unmarried, and then they become married, and you're still a green card holder, that petition that you filed will be automatically terminated as a matter of law. It's very important to know that. So one of the mistakes that I've noticed people are doing is the following. They go through the process as an unmarried son or daughter or child. They receive their visa as unmarried son or daughter or child. And then for some mysterious reason, prior to coming to the United States, they marry someone. Even though at the consulate, during their interview, usually they sign a document, an acknowledgement of the fact that their visa is going to be valid only as long as they're not married. And this person enters the United States happily, lives here for some time, and then decides, wait a second, I would like to sponsor my spouse who is left overseas. And when they do that, they of course have to show the marriage certificate. And here the interesting things start. Immigration finds out that the immigrant visa that they received and the green card as a result are not valid because a person before entry to the United States got married. The same is true if the child was sponsored to come to the United States after the parent received asylum using I-730 form. That I-730 petition was filed for the child. Interestingly enough, just today I was consulting somebody who told me that what happened to them is that they received the approval of I-730 petition when they were still not married and got married before entering the United States. A different attorney told this person that they will be fine, that they will be able to adjust their status in the United States after they enter the United States under this particular circumstances. Well, I had to open FAM, Foreign Affairs Manual, just to confirm that the child who was processed as an unmarried child must remain unmarried before they enter the United States in case of such sponsorship. Avoid these mistakes, okay? These are very easy mistakes to avoid. I'm not sure why people still fall for them. I think because they think somehow they will be fixing the situation later. But the truth is, if this is your situation when you used one type of a visa and then your situation changed, but you didn't inform authorities and entered the United States, incorrectly using the status that you no longer have, like unmarried person, guys, you will be charged with fraud and placed in removal proceedings. So it's not worth it. It's better to either wait and not get married until you come to the United States. The thing is this: you come to the United States, you convey the you accept the status, then you can get married, and then you'll be sponsoring your spouse through a family-based petition. So that's one example. Another example that I recently encountered was related to immediate family members. In the United States family immigration, there is such a group of people who are called immediate relatives. They would be spouses of US citizens, children of the US citizens who are under 21, and parents of the US citizens. So now we're talking about the situation when the US citizen married someone and that someone had children previously. They pre-started the family. And now US citizen would like to sponsor their spouse and those children. So someone online in those forums that you guys are Googling is spreading this misleading information that US citizen can file one petition for the entire family to be sponsored for a green card to come to the United States. This is not true. When we speak about immediate relatives, and now we're talking, for example, in this example, we talk about the wife, let's say, and a stepchild. Both of these people will require a separate petition by a US citizen in order to be sponsored, in order to become eligible for immigrant visas. I had a case where a person consulted with me. They stated that they were assured by multiple attorneys that if non-citizen's spouse files one petition for the spouse and the stepchild, it will be sufficient for the family to adjust status. So that's exactly what they've done. The mother of the child received a green card and the child was denied. And the family could not understand why. Why? Then they consulted with me. I said, well, I see the denial of the green card application, but where is the petition? Was the petition approved? They said, what petition? I said, the petition that was filed for the child. Well, we never filed petition for the child. I said, why? Well, because the lawyer told us several times that one petition for the mother, and that petition also includes information about the child, but it's not the petition for the child, it's petition for the mother, would be sufficient. So I was glad we uncovered the problem within the first 6 minutes of our consultation, and then we could speak about the weather, right? But that's the difference between when you doing research online, finding sometimes misleading information and information that you can rely on. It is true that if the petitioning spouse was the green card holder or a green card, one petition would indeed be sufficient to sponsor mother and the child, the stepchild. So these are the common problems that people sometimes experience in family-based immigration. Also, you need to know about another very important thing. It's possible to retain priority date in a family-based immigration if the same petitioner is filing for the same beneficiary. Thank you guys very much for joining me today. It was a pleasure as always. Please like, share this video. Help us to grow, to have more and more people following. We already have a lot of people following on Facebook. We would like to have more people following and joining, subscribing on YouTube. So thank you very much always for your support, for being my very nice, very supportive, always cheerful Facebook and YouTube family. I hope to see you soon, and thank you very much again.